going over the bills of exchange. Okay. And what we'll be doing is actually reading the bill of exchange. Okay. We had a bill of exchange already downloaded here on file. So we can go to it right now and get with it. Okay. How y'all doing this evening? Hope you're doing well. This broadcast is uh, um, being brought to you for the purposes of reading and learning and getting the understanding, comprehension of the Bills of Exchange Act. Okay, we already started the reading at the beginning. If you haven't already uh, viewed the content, please take the time to go over the videos that we have already produced that are covering the first portion of this instrument and explaining what these words and um, applicable understandings are using examples of what an action is, as well as the counterclaim and set off. That is approximately where we ended the last broadcast. And so we will begin right here where it says business of banking. Okay? The business of banking. So this area is trying to give you some understanding of the business of banking and the words that are related to that industry as it pertains to bills of exchange. Okay, let's get with it. And when we talk about bills of exchange, it is imperative that we understand that all documents, all applications, all forms, all affidavits, all artwork, all videos, all books, all titles, all brands and trademarks, all service marks are all considered as properties that are governed by this act. And the reason why they are properties that fall under the jurisdiction of this act is because the creator of that instrument may act in commerce to make an exchange of value for those instruments or forms of bills of exchange. And so we need to be understood that there are different forms of bills. And we need to understand that a subscription is a form of bill. A lot of people think that these words pertain to their common understanding of the words. A primary example of that is the use of the word bills, the use of the words pay, the use of the words borrower, or the understanding of the word borrower. Okay? If you think that you are a borrower, then you are a borrower. Okay? And these uh, words and their meanings are based upon the understanding of the person. It is not based upon this document. It is based on the assumption of the person. So when you assume a word means something, what you are doing by that assumption is agreeing to the terms. You're agreeing to the understanding. You're trusting that you understand the words that are being used. That is a risky um, arrangement in that regard because of the fact that you may be agreeing to something without full knowledge of what you're agreeing to. So we got to understand um, what degree of jurisdiction we give in each transaction. For example, when you um, go to a banking institution, and that banking institution or financial institution, however you want to address um, the borrower, please understand that they are the borrower. Unless they are a private lender. Private lenders are not borrowers. Private lenders are original creditors, oftentimes categorized as credit unions or depository banking institutions. Mortgage loan companies many times may be as well uh, set up with a trust that holds the notes and is listed as a private banking institution in some manner. Okay. A lot of times it's not public information who is actually holding, okay, the mortgage or the note. Okay, you have to do an audit, your MERS account, that's a mortgage electronic registry. And so when you borrow, that includes anybody or person's business. See there? People think everybody is uh, that they encounter in the corporate uh, business market. And I want to correct myself and not say corporate business market because all business entities are not corporations. You see right here, it says that includes anybody or persons or person's business. See, a person's business is a personal, private business, and it says whether incorporated public business or not. Let's be clear. It says incorporated public business or not. So that's an indicator. Here it is. It's considered private banking. See there? Some banking institutions that you may think is a big corporate entity may have um, designed uh, business structure to appear to be some big, large corporation, but may be in fact a private lender, just with a professional public appearance. Whoever carry on the business of borrowing is a banker. Okay? If you borrow, you're a banker. Okay? A person that's um, lending credit is a credit union. It's more qualified as a credit union. Okay? Bankrupt includes any person whose estate is vested in a trustee. Okay? And we said yesterday, through the last broadcast, I believe it was yesterday, that and where we left off, um, we did some explanation of the different types of estates, wills, and formations of trust. And in that explanation, we just touched on this section, um, and we also said that we were going to make note of the fact that we need to do some in-depth study and understanding of what vested means. Any person whose estate is vested in a trustee or assignee. Many times in the mortgage process, you'll hear the when they're foreclosing on the property, people who are experiencing foreclosure may be familiar with these terms. If you're not, then you need to become familiar with these terms, because if they eating you up in court, this is the reason why. You're not understanding that perhaps um, if you vest your estate in a trustee, then you it may offer you some protections. Okay, because what has happened is the banking institution has assigned uh, those powers that you left and abandoned. What I mean by left, because you did not vest them in a your desired trustee, your chosen grantee of the powers, power of attorney, however you want to verbalize that. Once you have on the record, that's what means vested. It's been placed on the record by a certified in an affidavit or some form of declaration, okay, that the powers of a trustee have been vested in uh, the testator's elected executor, okay. When you form a living will trust, whether revocable or irrevocable, okay, they are formed um, in the private, and they are vested in the public. What I mean by vested is that if you have something private, well, no one will be aware that it exists to honor to honor your will unless they know what your will is. Okay? And this is how many of these banking and mortgage institutions are accessing people's trust through liens in bankruptcy court that is non-judicial. It don't require for them to give you notice. And so they're doing all kinds of stuff in behind the scenes, okay, in the private to vest their interests. Uh, However small the percentage of rights that they have, they're making sure that it's still solidified on the record. And that's what vested means. But we'll do a little more uh, technical research on that word and get back with you, okay? But for now, let's just uh, keep reading so that we can get a full understanding as we go along and stay relevant to the topic, okay? Keep the explanations relevant to what we're reading right now so you don't get thrown off, okay? But everything that I'm speaking on is relevant to the information that's before you right now, okay? A signee is assigned by the testator or the person who created the trust. Same thing. Under the law for the time being in force relating to bankruptcy. Okay? And that means that if that person has affected a limited power of attorney, this is what they mean by this. They've been assigned, um, or they assigned themselves. They're an assignee. Okay? Somebody assigned it to them. And this is how some people have access through a power of attorney. They effected a power of attorney that essentially it says that they have the right or the what is it that they call the authority to do, the authority to act. Okay, the authorized representative, uh, the authorized party, party representative. It's all of those terms are all the same person or person or persons. In other words, um, you may have one executor that is the authorized party or the person with the power to act or the power to do or with fiduciary responsibility to act. Okay? They may or may not be the trustee. They could be managers of the trust. But however, whatever their title is, that is their position within the entity. Okay? And this is how they're acting on behalf of the assigned power. Okay? Under the law, for the time being, that's a limited power of attorney or um, yeah, a limited power of attorney or just a general power of attorney. But that's not that is and is not relevant to irrevocable trust where you've assigned a durable power of attorney. Um, it is not suggested that you assign a durable power of attorney to anyone else but perhaps your spouse or perhaps uh, your child beneficiary, because assigning that type of power is a irrevocable assignment. Well, it can be an irrevocable assignment. So you have to be careful giving any one person that particular type of power. And um, there's always a question on the table when one of these type of documents are presented in probate court, because there's a question of competence of why would this person um, assign this type of power to anyone else but themselves. Are they even competent enough to understand what type of power they have granted? And so it bears some responsibility. Speaking of bearers, we went over this area about the bearer. The testator bears some responsibility of competence to assign that type of power. So it's best to issue limited powers of attorney, or be very specific to its limitations in terms of what the person that's being given the power of attorney is allowed to do with that instrument, and the terms with which the powers that are given or relayed to the bearer. What are the terms? How long is this power last? A lot of times people don't revoke limited powers of attorney, which allows people to just um, access stuff and access their private information beyond the authority that was given to them. It leaves the door open, so to speak. Okay? And the Bible says, don't give place to the devil. In other words, don't leave the window open for a thief to crawl in. You at least close your window and lock it, right? Bearer means the person in possession of a bill, okay? Whoever has the bill, you the bearer. Until you pass it on or deliver, what we discussed yesterday about delivery, you is the bearer. You are also the holder. These are terms that are um, transfixed depending on um, what type of instrument you're discussing. Uh, Financial instruments um, are all considered bills, okay? Bills of exchange or notes of exchange. So let's just start referring to the bills as notes so we can get a clearer understanding of what a bill is. Okay? Let's just start referring to all notes and documents as bills so we can get a translatable uh, understanding of what delivery means as well. Because delivery means transfer of possession. So, okay, when you share online and you go to, say, for example, you go to one of your group pages on Facebook, all right, and then you share content from one of your group pages on your post uh, on your website, okay? Essentially, what you have done is you transferred possession, okay? You said, I want to hold a note on my, okay, I got a note I'm holding in my group. You posted an article or some type of information in your group, some original content, all right? And you say, I want to share my interest in this post outside of the perimeters of the Facebook platform, the Facebook marketplace. Okay? Just because you don't have that particular article or instrument in what Facebook designs to and called it, entitled it a marketplace, please understand anywhere that you have uh, uploaded and or created content within the platform is a note, okay? It is an instrument. And so you have interest and equitable value held in that note. And so what you can do, I'm just trying to give you an example outside of the perimeters of what people understand so they can understand these uh, principles apply to everything. People think that only their birth name has a principle. And that's where you're erring at in your understanding. There are principle with a principal. There are principal interests in everything. And what I mean by principle, that means that's like the origin of the interest. And so anything you do is an initiation of your interest. You're showing interest. You're performing your interest. When you share, you are conveying. People talk about conveying property. See? When they speak of real property, what do they call it? A property conveyance, a deed conveyance. It's all the same, no different. The only reason why people don't put them together is because they don't understand they already together. Because societal norms have allowed you to believe that they are separate. It's just like when a banking institution that's attempting to foreclose. How you gonna foreclose when you've already did a closing? That shit don't make no sense. That means you trying to go backwards and recant and try to claim rights from the beginning that you never had. That's what foreclose means. I'm finna try to go backwards and and gain possession by title by calling it a foreclosure, by calling it a default. What's a default? You know what a default is? A default means you go back to the original state, or to back to the beginning, or if not back to the beginning, it's like a reset. Okay, it's a reset to, okay, say for example, say if you want to go in your phone settings and it say, do you want to, you've already customized your settings, would you like to reset it back to what it was, to the default? settings. That means the default settings was generic and applicable to anyone. It showed no personal interest. Huh? It showed no personal interest. So you want to go back to the default, okay, stage. And the default don't mean that you have not kept your end of the bargain. Default means you never had nothing. You never had no rights to it in the beginning. That's the reason why they call it that. They're trying to assert that you never had a right to the property. You never gained a right to the property. You only had, they're trying to present to the court in a real subtle manner, okay? With these words, with the use of these words, okay? That they delivered a default notice to you, okay? They delivered a Section 22 notice to you. Section 22 notice is a notice of default. It's a well-known article that covers, that's in the conveyance of property, that covers redemption of your redemption clause that will allow you to redeem yourself at any time you can. They are required by law to allow you to redeem yourself. And people not understanding, in order to redeem yourself, you also have to let the other person off the hook. Bibles and bills. What does the Bible say? And deliver us from evil, from all evil. Okay? In the Our Father's prayer, it said, deliver us from all evil. All right? That means if you cut yourself loose, cut me loose too. Get me off the line. A lot of times, people will pursue a case against you because you're wanting to only, extricate yourself from responsibility or obligation, but you left them on the hook. And the Bible say, forgive us our debts. Forgive us our debts, okay? As, that means there's two things going on right there. Not just you getting off the hook. It say, forgive us our debts as we forgive our debtors. All right? So even if you have a God-like mentality to understand that you can forgive, let me correct myself, because most of the people don't even have that understanding. Let's start from where people mind is at. Some people can believe that they are gods, but some people have not even ventured upon having a God-like understanding that as a God, we have the right and authority to forgive. Let people off the hook. Forgive our debtors. Okay? It say, forgive us of our debts as we gods too. You know, we saying, Father, forgive us. We gonna forgive our brothers and sisters. We need you to forgive us. Everybody do some forgiving. You understand? Everybody do some forgiving. If people approach this with an acceptance mindset, as we um, pointed out the other day, if people will set out to learn these processes with a liquid understanding, liquid meaning you bendable, okay? That's what liquid means. I can pour a little in this cup and I can pour it a little bit in that, and I don't have to pour everything in for it to be you know how they say, is it half full, or if it's is it half empty? Well, that's not even what we discussing right now. What we discussing is, can I pour some into another cup? A whole nother cup. We don't even care about if it's half full or not. We want to know if we can move. That's what emotion is. All right? Can we move to divide this equally? Can we do that? Can we pour some into another cup? The Bible speaks about filling an empty vessel, okay? And it says that if you pour new wine into an old vessel, that old vessel won't be able to handle that new wine. It'll break, okay? So undoubtedly the rules say we can create a new vessel. And some people can't. It's hard for them to calculate to that. Not as easily as I said that. It's difficult to bridge over to that understanding when you're holding on to what you think words mean. It's very difficult to bridge over. That's what makes it seem like it's a gatekeeper. It's not no gatekeeper there other than what's in your mind. You need to transfer your interest in understanding, in possession of understanding. Have your holdings in possessions of understanding, so that the Bible says when the enemy come in like a flood, the Spirit of the Lord will lift up a standard against it. And what that means is when you are doing the right thing, sometimes you won't even have to speak up for yourself. Your works will speak for you. It's just like when you send a certified, something certified mail, right? And you are effectuating the postal rule. For those who don't know what the postal rule is, you out of your league, go somewhere else, okay? But if you're affecting the postal rule, okay, by sending a document, affidavit in the mail, or offer, contract, whatever, in the mail, it is considered by this act and by common law and other acts, the postal rule and so forth, as delivery, okay? That means you transfer the possession of bearership, a bearership. In other words, I was the bearer, but I transferred that responsibility to you. Now, I gave the carrier limited power of authority to carry this message, to carry this exchange, to tender this exchange. You might say, wait a minute now, you threw a word in there that, wait a minute now, we don't know what that word means. Okay, so let's move right on so we can get a full understanding of what tendering means. Actual or constructive from one person to another. Transfer of possession, actual or constructive from one person to another. Okay? Now, constructive delivery means you told somebody how to, okay, in criminal law, I understand that constructive delivery it didn't mean you sold the person some drugs. Okay. What it means is you told somebody how to, not how to, where, the location of something illegal. Okay. You told them the location. You directed them. You were the facilitator, like the broker, okay? You were the broker for the dealer. Even though you might not even work for the dealer, you may be a customer yourself, right? And then an undercover police officer pretending to be another addict say, man, I need to get me a fix. You know somebody with some fentanyl? Man, man, that shit hard to find, man. I'm trying to find me somebody that got some fentanyl, man. I'm telling you, I'm willing to pay. I want to buy $100 worth, $200 worth, depending on how they gonna serve me. All right. So then, if you are knowledgeable of where they can get that particular drug that they're asking or inquiring about, okay? And they have already let you know that they are trying to make up a purchase that you are aware of that's illegal, okay? You don't sell fentanyl, you ain't in the drug business. So you don't have no parts of that. It's just like if you didn't do drugs, would you be trying to help them trying to find a dope dealer? No, you wouldn't. So if you own drugs and you assist somebody to go try to find somebody to help them get their drugs, you're doing it because you have some foreseeable benefit in sealing that deal, closing that, and them closing on that deal. So that is what the law considered as foreseeable or reasonable expectation of procurement. In other words, you was going to get some type of benefit out of that transaction that was illegal. That is what's called constructive delivery. Even though you're not the one that sold them the drugs, you are the one that helped them to close on the deal that was activity, illegal business activity. In that regard, hopefully I've helped some people who are street knowledgeable to have a relatable understanding of what constructive delivery is when we're dealing uh, with papers and have a translatable understanding when it comes to contracts. You made, okay, if you made some type of deal with that dealer, say, man, if I bring you a customer, you know, for example, especially in an industry like that, where it's very dangerous and risky and a crime that carries high penalties, okay? A lot of times that type of business is by referral, okay? A broker. A broker ain't nothing but someone who tell you how to get to somebody else to seal the deal. A lawyer is a broker, and lawyers do uh, contracts by constructive um operation or constructive contribution. In other words, they construct the deal. Today, I was speaking with a realtor. A realtor is also a broker. They are a real property broker. In other words, they help you seal the deal. They help you close on the deal. Uh, uh, Finance investment broker is known as a broker, but any type of referral service is a broker. They're a go-between. That's what constructive delivery is. Okay? And when you place your instruments in that mailbox, the mailbox is the property of the United States postal system, right? But that's a private company. So they are constructive deliverers, meaning they've been trusted with the duty to handle financial instruments. And it is their responsibility, the postmaster, it is the postmaster's responsibility to make sure that those instruments are secure. That's why it's placed in that type of armored box, sealed, okay? You know how they say signed, sealed, and delivered? If you signed it, you sealed the package, and you put it in the mailbox that's considered delivered. Signed, sealed, and delivered. That's where that song comes from. Signed, sealed, delivered, I'm yours, baby. Yeah. Signed, sealed, delivered. That's your contract. Now, once you deliver that contract, that person can send you and deliver it back to you. Okay, it's not final when you deliver it, but I will tell you this. This is the power of sending certified mail. You also have power in registered mail. There's different types of powers or level of superior interest in the different types of documents. Okay, the different types of perfected instrument.
It's still perfected. One registers and one gives a certificate. One is registration. It's a registration, title registration. The other one is a certificate of title, certificate of birth. Okay? Same thing. We'll end right there because that was powerful. Y'all need to marinate on that.